Hello, everybody. This is Leanne the lawyer, and I am here with part 4 of my series on criminal law. Today's lecture is going to focus on crimes against property and habitation. So let's get started. So first, let's figure out, what is this property? What is this habitation, right? So property, if you've had a property class, you understand that there are two types of property in the law: real property and personal property. Real property is land and those things that are attached to the land, like a house with a foundation and perhaps a basement. So those types of things you can't move around, that's going to be your real property. Now, personal property is mostly what we're going to be talking about today, and those are things that you can move. For example, your car, your laptop, your phone, your clothes. Those types of things are personal property. Now, what about habitation? Because I said that this is going to be about crimes against property and also against habitation. Well, habitation is going to refer to your home, but historically, a home hasn't been considered just merely property. It's a refuge. It is a sanctuary. So there are special things under the common law that I'm going to be sharing with you that were developed in order to protect this sacred space where you feel you're most safe. You should be able to go into your home, shut the door, turn off the lights, go to bed, and not feel like you're going to be violated in some way, like somebody's going to come into your home and start stealing things or hurting you, okay? Now, I mentioned hurting you, okay? So some of the crimes that we're going to be talking about today, even though we're zeroed in, we're focused on property and habitation, some of these crimes are going to have an element to them that deals with a crime against a person, okay? So they're not going to be exclusively property. And also, just a little reminder, we are going to be talking about how these crimes, each crime I talk about, I'm going to talk about a little bit of a historical context. Where does it come from? How does the common law traditionally dealt with this crime? Then we're going to look at how it has evolved. And I'm going to look generally how today states and the federal government are dealing with these particular crimes. So I'm going to be talking a lot in generalities because most states, as you know, have slightly different laws. They're all very similar, but they're slightly different. So if you are curious about what your particular state does, please feel free to look it up, and you'll see that it's probably very close to the generalizations that I'm going to be talking about today. Also, the Model Penal Code, just a reminder, it is not law. It's not something you should cite to as law or believe that it is law. The Model Penal Code is simply a suggestion of what the ideal law might look like. So it's actually not law unless it has been adopted by and enacted by a state legislature or the federal government in some way. Okay, so just remember that the Model Penal Code is just a suggestion, although it is something that legal scholars often look to understand particular laws. It's not the actual law itself. Okay, so the first crime that we are going to be talking about is arson. Now, arson goes way back. If you think about it, arson deals with fire. Human beings have always had access to fire. And when you have your dwelling or something that's important to you and someone else sets it on fire, that has long been thought of as a bad thing. It is still a bad thing. So historically, arson has not just been a crime against property, but also against that very sacred space that we were talking about, habitation. So under the common law, it was the malicious and unlawful burning of a building. We still have that. That is still the basic definition of arson. Now, a nice little nuance under the common law, which has since been corrected, but if the fire actually never touched the building, then it was not considered arson. So if the fire raged on right next to the building, completely destroyed the building and everything in it with smoke damage, that was not enough to be considered arson. You actually had to have flames touch the structure. Now, the elements at common law were, number one, it had to be malicious. So that's talking about the mental state. Had to be a burning.
And it had to be the dwelling house of another person. You see how that habitation comes in. So, and of course, a dwelling was defined as a structure inhabited by people. Now, I think you could probably pick out the flaws in this. Historically, there were problems with arson because if you look at those elements, it actually allowed you to burn down your own house. If you wanted to set your house on fire, great, even if you had a malicious intent for burning down your own house. It also prevented the prosecution of people who burned down businesses because businesses are not inhabited by people. What about somebody's barn or an outbuilding that was not attached to the house? It's still a bad thing, right, to have burned those things down, but it just wasn't considered arson historically under the common law. Additionally, explosions, if you used a bomb to destroy a building, that didn't count as arson because technically it was not a burning. So let's fast forward to today and also check out how the Model Penal Code has addressed arson over time. What's that ideal law, right? Well, today, arson has been broadened to sort of address those flaws that existed under the common law. So now it is a crime to burn down your own home, unless, of course, you have permits and you're trying to, you've talked to people and you said, hey, I need to destroy this so I can build something else here. And maybe burning is the way you want to go about some of it. No, this covers things where you're sort of burning down your house because you want the insurance money, okay? So if that house is burned, a place where human beings live, a dwelling, that's often considered in today's statutes as aggravated arson. It's worse than just a regular arson where you're burning down a building that is not occupied by people or, a business where people, are not in it. It's not a dwelling house. It's not someone's home. It's still going to be arson. It's still a terrible thing, but it's not as bad as if you're burning down a house where people live and sleep. Okay. Also, most statutes and the Model Penal Code recognize explosions now as a burning. Now, most states use degrees: first degree, second degree, third degree arson. I'm sure you've heard that. So what's covered under most first-degree arson statutes? Well, that's going to be your dwelling. That's going to be your sacred place, your habitation. Second-degree arson are going to be things like your uninhabited structures, okay? That garage that's not attached to the house, okay? Can't be attached to the house. Something separate, you just got cars in there and your lawnmower. That's going to be your second-degree arson. Your third-degree arson, your lowest form of arson, is where personal property is set on fire. So, for example, a car, that's personal property. Some people, and there's also specific statutes dealing with the burning of a car because most generally, often, that involves some type of insurance fraud, also burning down your own residence or your business. Also, some type of insurance fraud would be involved in that. So there'd be multiple crimes, but those are your degrees. Now, talking about mental state, we said malicious under the common law, right? Under the Model Penal Code, as long as you know what you're doing, purposeful, or you're extremely reckless in what you're doing, then that's good enough for arson, okay? So for example, I say, I want to burn down Joe's house. So I'm going to take my kerosene and I'm going to take my matches and I'm going to go over to Joe's house. I'm going to dump the kerosene everywhere and I'm intentionally setting it on fire. That's just a mean, malicious thing, right? It still falls under that malicious burning of a dwelling. It was purposeful, though. I had the intent. Now, recklessness is something where you're just so flagrantly reckless with your fire that you're going to burn down somebody's house and you don't care if that happens. You know it could happen, but you're not intentionally trying to set that house on fire or that building on fire. It's just, yeah, I just don't choose to be careful here. One thing I often think about is that silly prank where somebody lights a bag of dog poop on fire and they put it in front of somebody's front door and they ring the doorbell and they run away. Hee hee hee. Okay, so now what you have is on somebody's porch right in front of their door, something that is on fire. You have purposely put fire on somebody's front porch. Now, your intention is, hey, I just want to prank the owner. I want them to open the door and I want them to stomp out that fire. and then get dog poop all over their shoe and then all over the porch. Ha ha ha. Well, that's being extremely reckless, isn't it? Don't you know that if that person doesn't actually come out, that it could actually light that person's house on fire? Okay, that is a very reckless act. So if that does involve setting the house on fire, in my opinion, I would argue in court that that was recklessness, and that would meet that type of situation under the Model Penal Code and under many statutes that have enacted the Model Penal Code. Okay, and also in today's arson, the fire does not need to touch the structure. Setting the fire is enough for arson. Okay, so the next crime we're going to be discussing is burglary. So let's look a little bit about the history and the common law of burglary. In this case, the arson, we had a crime against property and habitation. In burglary, we not only have a crime against property and habitation, but also against the person. So the common law elements for burglary was, number one, it's the breaking and entering, two, of another's dwelling, there's the habitation, at night, see, at nighttime, four, for the purpose of committing a felony once inside. And the purpose may be theft, rape, murder, or another felony. Your whole idea of entering that dwelling home was to commit some sort of felony once you got inside. Now, why is this a crime against the person? Well, some of those crimes are to be committed against the person, like rape and murder. However, when you enter a person's home at night, isn't it more likely they're gonna be home and they're gonna be inside? And in fact, they're gonna be in a vulnerable state. They're most likely going to be sleeping. That's why burglary is such a terrible crime. Because if you break into somebody's house at night, it really is a violation of that sacred space. Okay, so now the first element, breaking and entering. So breaking under the common law had to be real. You actually had to break something, forced entry, okay? Or it had to be constructive breaking, that you lied to somebody so that you could get into that home. You tell them you're a salesperson and you're not, okay? So you entered that home through fraud. Or the person opened the door, you didn't have to break the door, but then you pushed your way in, okay? That's those real types of breakings. If you simply just pass through an open door without using force, without using fraud, that was not technically, under the common law, considered to be a breaking. Now, in modern day statutes, this idea of breaking has been eliminated and replaced generally with this idea of unlawful entry. If you are not supposed to be there, okay, that's trespassing. Obviously, we talked about fraud, and in that case, breakings are all unlawful, okay? So it's no longer this idea that you actually have to break something for it to be a breaking and entering. Now, no jurisdictions still require that the property be a dwelling. It no longer has to be a home, okay? You can actually break into somebody's business or into somebody's barn or an outbuilding. If you're not supposed to be there, you shouldn't be going inside, right? However, if you do break into somebody's home, remember we talked about that as a sacred space, you're going to be punished more severely if it was a dwelling, or if when you entered, even if it wasn't a dwelling, if a human being was inside once you got in there. So you might be going into a barn and you think it's full of cows or horses, and you get in there and the farmer is in there. That is going to be more severe punishment because the farmer was in that barn. Okay. At night is no longer required, but if it does happen at night, you're looking at an aggravated burglary. It's also aggravated if you had a weapon with you, if you were carrying a knife or a gun or a club or something, anything that could be used as a weapon, you're going to be looking at aggravated burglary. Also, many states still continue this idea that you have to have the intent once you are inside to commit a felony. So once you're inside and you're planning to go in there to steal all the jewelry, very valuable jewelry, that's a felony. You're going in there to kill the occupant. That obviously is a felony. You have that intent when you enter. So many states still require that for burglary. Now, there are, of course, lesser included offenses. If you go in there and you're just trying to mess around and you don't really have the intent to commit a felony therein, it's not a burglary, it's some other lesser crime. Okay, so we're talking about burglary. The common elements that you're going to see across the board today with burglary in many different states are, number one, you need that unlawful entry. Okay. 2, of any structure or building. 3, for the purpose of committing a felony or stealing from the premises, because not all stealing rises to the level of a felony. You might be trying to steal something that's not worth very much and it's still considered a misdemeanor. Okay, so, or stealing from the premises once you get inside. All right, now we're going to move into theft crimes. Now, this is an underlying crime for a lot of other crimes. When you take something that doesn't belong to you and it's at the detriment of another person. Think about how basic that is. It's so basic that, in fact, this law has been around for about 600 years. So there's going to be a lot to cover here when I talk about the fundamental basics of the basic theft crime called larceny. This is stealing. So in legal terminology, we don't say stealing, we say larceny. So larceny was the very first theft crime in the common law. Okay. Now, originally larceny was designed to prevent what was called a breach of peace. Okay. Having people fight over possession of property. It wasn't actually designed to protect ownership of the property. It was just there to prevent these fights, the breach of the peace. It was very narrowly defined at first, but over time it has evolved because of all the different nuances that may come into play whenever you're talking about taking something that isn't yours. Larceny was so serious for such a long time that earliest larceny was punishable by death. Now, it didn't include things like thefts by fraud, where you're lying to get something that doesn't belong to you. That's deceptive practices. Those were less likely to result in a breach of peace because a lot of times people had something taken from them and they didn't realize for a while that something had been taken from them. So that immediate fight over possession wasn't occurring. So 2 other theft crimes eventually had to be added to fill this idea that they excluded thefts by fraud. They added embezzlement and false pretenses to this family of theft. So there's going to be these 3 main theft crimes. There's going to be larceny, embezzlement, and false pretenses. Let's focus on larceny here for a few minutes. Some states have changed their common law definitions of larceny, embezzlement, and false pretenses because times have changed. They needed to do that in order to more comprehensively cover things like computer crimes, electronic banking, anything that's occurred because of the many technological advances that we've had over the last 600 years. So we're looking at really old crimes that were developed ages ago. And of course, they need to be tweaked and changed and amended over time to make sure that we're covering all of our bases. Other states have entirely abandoned the common law theft crimes, those 3 major ones, larceny, embezzlement, false pretenses. It's not that they abandoned them, but they've replaced them with these what are called Consolidated Theft Statutes that we'll talk about in a little bit. All right, so when you're talking about larceny specifically, here are the common law elements. Number 1, it was the trespassory taking and carrying away, also known as asportation, of personal property of another with the intent to permanently deprive the owner of possession. In this common law larceny, the actus reus was the taking and the carrying away of that personal property. And the mental state, the mens rea, was the intent to permanently deprive the owner of possession. That's it. That's right. I know I keep saying stealing. Legally, in the legal context, we're not really, it is stealing, but we call it larceny. Okay. Everybody's familiar with this concept. But let's look at what you had to prove if you had to show larceny. Remember, in the early days, You died. You got killed, okay? It was punishable by death if you stole something. So trespassory taking, that's that first element. What does it mean? It means without consent. You took something and you didn't have permission to do it. If you took something with permission and you didn't give the item back, that was not larceny. I have my friends who are like, hey, can I have this, shirt? I want to wear it. And I'm like, yeah, go ahead. But then they never return it. I feel kind of like, hey, should I ask them for it back? I mean, they never gave it back, right? I'm sure everybody, well, under the common law, that was not larceny. There was no theft there because they initially got it with permission. They just failed to give it back, okay? In that case, under the common law, they have lawfully acquired possession of that item. Now, there's something called constructive possession. This was developed in order to protect employers because they would entrust property to their employees. So if I had a little store and I hire somebody to work at that store for me, I'm entrusting them with possession of a lot of things. The money that's in the cash register, all of the items that are in the store. It's not their stuff, it's my stuff, but I'm entrusting it to them. That is something called constructive possession. Under this theory, the employer actually retained what is called the constructive possession of the property while it was under the employee's control. They had to add that element. Otherwise, if it was under their control, they could try to make the argument that it was theirs. Okay. All right. The next element is asportation, the carrying away. So you've taken something without consent, and now under larceny, you need to take it somewhere. You need to carry it away. Even a slight movement constituted asportation. It did not have to be carried. For example, riding a horse away would be asportation. So you didn't actually have to carry the item. You could push it, you could pull it, you could ride it, okay? You don't just have to, but even just a tiny movement was enough to count as asportation. Now, of course, personal property is anything that's movable. It's tangible property. When I think of the word tangible in the law, it's like anything you can touch and feel and see is tangible. Intangible property are things that you know, like, for example, ownership rights, like who owns something, stocks, bonds, documents, things that represent something else. That's kind of intangible property. For example, like a copyright. People know you own that thing because you created that, you have those rights, but it's not something you can pick up and carry away. Okay, so we're talking specifically about personal property. Today, most statutes have been broadened to include all types of property, even those intangible things. But just remember that under the common law, it wasn't larceny to steal something that was intangible. Okay, so land and items that are attached to the land, real property, that would be like a house, they are not personal property as required by the elements, and so therefore they are not covered. The theft of those things is not covered by the larceny statutes, by the larceny elements. Okay, so it has to be property of another person. So we've got the trespassory taking, we've got the carrying away, and now it has to belong to somebody else. You cannot steal from yourself under the common law larceny. And also, this extended to partnerships, people that you had a joint tenant relationship with, spouses. You guys were considered to be one thing, one entity. You couldn't steal from each other. So you couldn't steal from your husband or wife. You couldn't steal from somebody that you had a joint tenancy relationship with, and that's under property law. So you just couldn't steal from them. So under larceny, it had to be from another person, a completely separate entity from you. Now, mens rea, what's the mental state? Well, you had to take something with the intention to permanently deprive the other person of the property. So if you took it, but you intended to return it, not a larceny under the common law. However, if the property was held so long that the property lost value or that the property was somehow subjected to substantial risk, then it became a larceny. So my friend who took my shirt with my permission, has kept it so long, it's now out of style. It's out of fashion. It's lost value to me. Maybe, it doesn't fit me anymore. So it's lost its value. Maybe they washed it and shrunk it, right? Okay. That we could try to argue that that's some type of larceny. Or if they subjected my personal property to substantial risk, like they decided that they were going to wear it and wrestle a bear. Well, the bear might tear my shirt with their massive claws. And that person knew very well, whenever they were wrestling that bear with my shirt on, that they were subjecting it to substantial risk. So therefore, I could argue that that was a larceny. Also, if there's a good faith belief that you actually own the property and that it's not someone else's, then there's no larceny. Like if my friend came over and said, "Hey, isn't that my shirt? Like that's my shirt." And I'm like, and I just don't say anything. I remain silent. And she thinks it's her shirt, so she takes it. If she really had a good faith belief because she had a shirt just like that, exactly identical, we had the same shirt, same size, same color, same style, everything, she might have had a really good faith belief that it belonged to her, so that when she took it and carried it away, she could make the argument that she really didn't have the mental state, the mens rea, to have committed a larceny. All right, so moving on in our family of theft crimes. Now, the first member of our family was larceny, that crime that's over 600 years old. We talked about how over time it had to evolve to address certain situations that would come up. One of the situations that would come up is that instead of gaining the property without consent, sometimes people did gain property with consent, but after they gained consent to have possession of that property, they abused that trust in some way. Okay? Therefore, the crime of embezzlement kind of came in. Imagine that you are a shop owner and you hire somebody, and when you hire that person, when you are not there, they are in possession of all of the items in the store, including all of the money in the register. Okay? So they have, remember we talked about constructive possession. So now what happens is they were given consent to have that property, right? Well, what if they take that property and they make it their own in some way? That's embezzlement. So embezzlement was created to address those situations that did not meet the element of trespassery, taking, and larceny, and those situations that only apply to tangible property. Now, today, of course, it applies to nearly all forms of property, personal property. Embezzlement is a very broad crime. At common law, these were the elements. Number 1, the conversion. Number 2, of personal property. 3, of another. 4, by one who has acquired lawful possession. 5, with an intent to defraud the owner. So let's look at that a little bit closer. What is conversion? Well, this is any act that deprives an owner of property without the owner's permission and without just cause. It's the unauthorized control over property with an intent to permanently deprive the owner of its possession, or which substantially interferes with the rights of the owner. So that person who works in the store, that money that's in the cash register, what if they take it out of the cash register and they put it in their pocket? Okay? And they wanted to permanently deprive the owner of the possession. It is now theirs. Now, that's very simple. It's a very simplified form. How about a bank teller who an individual hands the bank teller some money to deposit into their checking account? And the bank teller says, "Thank you very much." And the person walks away. And the bank teller takes that money that they just lawfully, with consent, that person who came into the bank handed it to them. They take that money and they put it into their pocket. What about the accountant who is in charge of making sure all the money gets deposited into the right bank accounts and it is being used to pay bills and so on and so forth, and whoever has hired this accountant entrusts them with the control over all of this banking information. Well, what if the accountant creates an account and they put some of the money that doesn't belong to them, but they've been authorized to take control over this, to do things with it, to pay bills, to deposit it. But they take it and they deposit it into an account in their own name. Okay? So they have to have this mental state, this intent to defraud. They can't accidentally put money in the wrong place or accidentally take money that doesn't belong to them. Okay? So they have to have this intent to defraud. So accounting errors, mistakes don't really count. Okay? Negligent conversion is not embezzlement. You just were sloppy and you didn't understand how to do proper accounting. So a defense to embezzlement would be, hey, I just didn't have the mental state. And that would be somewhere along the lines of, I made a mistake of fact or I made a mistake of law. Really sorry. Yeah, I was kind of dumb when I did that, but I didn't do it with the intent to defraud anyone. The next member of the family in our family of theft crimes, and just to recap, larceny, embezzlement, and now false pretenses. Now, common law did not criminalize lies designed to gain ownership of property. You could lie all day long to get that ownership of the property, and if the person believed you, then hey, that's their fault. That completely falls in line with the Latin term caveat emptor, which translates to let the buyer beware. So when you buy something and you're listening to somebody and they're telling you all these wonderful things about this property, if you believe them about that personal property, then that part of that responsibility falls on you under this idea of caveat emptor. Okay? But people still felt wrong. They felt like, hey, there should be something that covers this. If somebody's really out of line and really is lying to you and they have a really, they have that intent to defraud you, not just lie to you or puffery, but they're really trying to lie to you. That's where false pretenses was born. It came into play to address this gap that we had in the law. So at common law, the elements of false pretenses were, number one, a false representation, a lie. Of two, a material present or past fact. Like, showing you a cow and saying, hey, this cow is fertile. And if you buy this cow, you can make more cows with this cow. Okay. That's talking about a present fact that this cow is indeed fertile and can make more cows. What if you lie about a past fact? Oh, this cow has already given birth. So we know that this cow has a good track record and has given birth to healthy calves. Okay. I use that because there were some cow cases, a long time ago. So that would be a material fact that would be important to the person buying that cow if they wanted to use that cow for breeding purposes. Now, when they make that statement, they have to make it with three, the knowledge that the fact is false. Maybe the person selling the cow knows, number one, that this cow is like way too old to give birth and has never given birth because there's something wrong with it. It's defective in some way, right? And four, you have to do it with an intent to defraud the victim. He's just trying to get as much money as he can out of this cow. He knows he's lying. He knows the more he lies, the more this buyer is going to buy this cow and the more money that he's going to get. And number five, thereby causing the victim to pass title to property to the actor. Okay? So this person is lying to you, and now what they're doing is they're giving you money, which is their money that they're giving you because you lied about this cow. So that's pretty much false pretenses. So let's look closer at false representation. What exactly does it mean by a lie? Well, it can be either oral or it can be in writing, and it can even be implied by somebody's actions. Now, caveat emptor, remember, let the buyer beware. It's still followed. However, the law requires that any affirmative statements or implications from actions be true. So anything that this person, so let the buyer beware. But at the same time, the person who is trying to sell you this item has to say things that are true. And it has to be if you're just not asking the right questions, if you're not knowledgeable, a lot of times they'll sell something as is. Hey, take it as it is. I'm not guaranteeing that there's anything that this works, that it is what it looks like, that type of thing. So there's still buyer beware, but you can't lie to somebody. You can't commit a false representation. Okay, now the false representation must be material and it must relate to a present or a past fact. I talked about that. Opinions and future predictions cannot be the basis of false pretenses. Now, this comes into play a lot because somebody will say, I think this is the greatest cow that ever lived. Okay, that's an opinion. This is the fastest car. Okay, that's probably, but people understand that something like that is something called puffery. Okay, where you're trying to, make something sound better than it is. Future predictions, like I predict that this cow is going to have 20 calves in its lifetime. You don't know that, okay? Those are not the basis of false pretenses because the buyer should be aware that these are just opinions of the person and that they are nobody can predict the future. So the buyer has to be sort of on notice, and you can't say somebody has made a false representation if they're simply giving their opinion or they're talking about something that might happen in the future. Now, it must be proved that the defendant knew the statement was false. Okay? They have to know that they're lying. Most jurisdictions will also accept recklessness when it comes to the knowledge required. So, this person just didn't do their homework. They're selling you something and they're like, yeah, I think this has this kind of engine. If you're talking about a car, I don't even know enough about cars to give you an example. So, but somebody's telling you, they just haven't done their research and they're selling you something and they're acting like they know a little bit more about it than they do. They're not intentionally lying to you. They just haven't really, they're recklessly giving you information. Okay? All right, so now there actually has to be an intent to defraud. Okay, if you think that the property belongs to you, that's a defense. You're not actually, so for example, let's say you think your grandma gave you her ring and you had a conversation with grandma and you thought after you left that conversation that grandma was giving you that ring. But when grandma left that conversation, she thought that she was letting you borrow the ring for a week. In the meantime, you needed money, so you decided that you were going to sell grandma's ring, well, what you now believe is your ring, and you tell somebody, hey, this is my ring, would you like to buy it? And they say yes. Okay, you don't really have the intent to defraud anybody. You're not intentionally lying about the proper ownership or the proper title to that property. You just had a mistake. You made a mistake. You had a bona fide belief that the property belonged to you. Okay, so additionally, the victim has to be defrauded. Now, let's say grandma didn't give you that ring. You're 100% positive that that ring is not yours. It is grandma's. She's just letting you borrow it for a week or 2 weeks or whatever, okay? You know this. Now, you're going to try to sell it to somebody. And you say, hey, yeah, my grandma gave me this ring. You know you're lying at that point, right? You know the ring does not belong to you. Now, what if the person you're trying to sell it to overheard the conversation between you and your grandma, and that person knows that the ring actually belongs to grandma and that you don't really have title to that, but they go ahead and buy it anyway? That person wasn't defrauded. They knew that you were giving them a false statement and they let it happen. So there's no crime there. Okay, that's just two really unpleasant people buying and selling a ring that doesn't belong to either one of them technically, right? Now, the misrepresentation has to be the reason that the victim passed the title to the defendant. So now your lie about whatever it is, the cow, that has to be the reason that the victim passed title to the defendant. Perhaps the defendant in that situation with the cow where they were talking about the cow being fertile, the only reason why the defendant would have purchased this cow is because they want to use it for breeding purposes. And you know that that cow can never reproduce, okay? So that misrepresentation is the only reason why the victim gave you money. Now, transferring possession is not enough. title, which is ownership, must have passed. So it has to be clear that I'm giving you money, which is now yours, in exchange for you giving me that cow that is now mine. It can't just be that we traded property without trading title. If only possession was transferred, this was a separate crime called larceny by trick. Okay, so we're not going to go into great detail about that because it doesn't really exist anymore. But it's this idea that actual title has to be transferred, okay? Not just possession alone. Now, only tangible personal property was covered by the common law. Today, of course, false pretenses, like everything else in our family of theft crimes, includes all property that would be protected by larceny that we've talked about already. All right, so something sort of under this caveat of, under this umbrella of false pretenses is something called fraudulent checks. Okay, so this is a type of false pretenses. It involves acquiring property or money by writing a check from an account that has insufficient funds to cover the draft. You know you don't have enough money in your bank account, but you write that check anyway. Okay, so you know a long time ago they used to call those rubber checks because they knew they were going to bounce when they got to the bank. Okay, that's actually false pretenses because you're lying about the amount of money, okay, that you have in your bank account. And when you write the check, you're getting something of value in return for this money that you know isn't there. Okay. Now, most states have what are, we would refer to as bad check laws. Okay. And the common elements in all the states that have these is number one, the mens rea, the mental state, may be proven by showing either an intent to defraud the payee, which is the person who's getting the check, okay, or knowledge that there were insufficient funds in the account. So either you were trying purposely, okay, to defraud the payee. A lot of people are like, yeah, I mean, I thought I might be able to get enough money in there by the time that check went through. You're sort of playing that game, right? So you're not really trying to defraud the person that you wrote the check to, but you also know that there's insufficient funds in the account at the time you wrote the check, okay? Number two, so that's your mental state. Number two, the check must be taken in exchange for something of value. Either you're paying a bill where you owe money, right, for your electric bill or your water bill or whatever, or you're at a store and you're buying groceries or you're buying clothes or you're buying a bicycle or something and you wrote a check in exchange for that. Now, and number three, there must actually have been insufficient funds in the account. That actually has to exist. That there just isn't enough money, and that's going to be covered by your bad check laws. Something else in this family of false pretenses is called mail fraud. Now, this is where you're using the United States Postal Service, the mail system, with an intent to defraud another of money or property. Okay. So you're using the mail in some way to get something from somebody else using false pretenses. A lot of times, that people don't think of mail anymore, but anything involving the United States Postal System, if you send a letter to an elderly person and you say, if you send me $400, I'll make sure that your son gets such and such. Okay. And the elderly person's like, oh, my son really needs that thing. I'm going to send this person $400. And they send you $400 and you're lying. You don't even know this person's son. You're just trying to get that money, that $400. If you're using the Postal Service, if you're using the mail to do that, it is a crime against the United States because the mail system is run by the federal agency and it is a federal crime. Now, the intended victim doesn't even have to be defrauded. The act of sending the mail with the intent to defraud is the crime itself. So let's say this elderly person realized that this was a fake letter. As long as they alerted the authorities, and even if you didn't get the money and the person wasn't defrauded, you're still guilty because you sent that through the mail. Okay, also in this family of theft crimes in modern day, we have something called RICO, you may have heard of, which is the Racketeer Influenced and Corrupt Organizations Act. This was enacted in the early 1970s, and it was around to sort of curb organized crime Back then, it was mostly dealing with the mob or the mafia, okay? And RICO, the way it works is that if you look at the third bullet point there, in order to establish a RICO violation, the United States must prove that number one, the defendant received money or income, okay? So that's going to be your mobster, okay? Two, from a pattern of racketeering activity, which we'll go over in the next slide. And then three, invested that money in an enterprise or business, okay? Four, which is in interstate commerce or affects interstate commerce. Now, interstate commerce is anytime money or things go over state lines. So you're going to be talking about interstate commerce, right? So all businesses today are subject to RICO, not just your traditional organized crime, your mobsters. So it's been expanded. So let's look at what could be considered racketeering activity, because that is the really important part of RICO. So the pattern, it has to be a pattern. Pattern means you've done two or more things, two or more acts. These are referred to as predicate acts. Racketeering activity is defined by statute, which provides a list of state and federal crimes. Now remember, you have to do two or more of these things, okay? State crime examples include murder, kidnapping, extortion. So if you got two murders or one murder and a kidnapping, one murder and extortion, that's two, right? And drug sales and transportation. Now, obviously, you can see how drugs play a very important role in RICO now because of how drugs are going across state lines all the time, right? Now, there are some federal crimes. Those include mail fraud. We talked about mail fraud, right? Wire fraud, human trafficking, securities fraud, and bribery, okay? Now, if you have a pattern of doing two or more of these things, then that sets up that idea of racketeering activity, okay? There's a pattern of it. Now, in RICO, what is very important if you are going to become a criminal defense attorney and you're working with your client, a big deal is something called forfeiture. This is where the government comes in and they take the property and the money of a defendant. And they take it during the criminal proceedings. And this is in addition to any fines. What they do is they try to take all of the property they thought was bought by this illicit money that was gained. Okay? Defendants can lose their entire business. They can lose their personal belongings if it is believed that that was purchased through their criminal activity. So forfeiture is a really big deal, and it can include the acquiring by the government of a lot of money and property by the defendants in these RICO cases. All right, so also included in our family of theft crimes is forgery. Now, everybody knows what forgery is, right? You always, in the movies, there's somebody who signs their name to a document and they know they're not that person. They've just signed somebody else's name there, right? So really, the idea of forgery is you're making a fake document or you're altering a real document with the intent to commit fraud. It's very simple. The elements of forgery are, number one, the making of two, false documents or the alteration of existing documents, making them false. Three, and then passing that document to another with the intent to defraud. So in forgery, the act is making the document and the passing of the document. The mental state or the mens rea is the knowledge that the document was false and that you have an intent to defraud. Okay, pretty simple. Now, in some states, forgery and uttering are separate crimes. You may have heard of this. In my state, forgery and uttering are separate crimes. Forgery is making of the false document and possessing it with an intent to defraud, whereas uttering is the crime of presenting the document to the victim with an intent to defraud. Actually, I had a case like this where I represented one of the defendants. There were two defendants, so it was a boyfriend and a girlfriend. And the girlfriend had taken a checkbook from her aunt, and the girlfriend filled out the check, signed her aunt's name. Okay, so she did the forgery. Okay, she made a false document. She had the intent to defraud. She then handed that check to her boyfriend. The boyfriend then took that check and went into a store and he gave it to the store clerk to buy, I think it was like cigarettes or something like that, right? Okay? So she forged because she made the document. She had the intent to defraud, right? And the boyfriend, he uttered it because he presented the document to the store clerk, and he had an intent to defraud. He knew it was a false document. So you see how those crimes are different. So she was charged with forgery, and he was charged with uttering. So in some states, they are two separate crimes. Okay, so also in the theft crime family is you have something called receiving stolen property. This is the criminal offense of actually getting or concealing property that you know is stolen, okay? The reason why this law was created was to address those situations where people who are called fences, okay? These are people who intentionally purchase stolen property, and they're going to resell the property for a profit. They know it's stolen, and they're just trying to move it, okay? And they're trying to sell it to somebody else because they're going to make some money. All right. Now, the elements of receiving stolen properties. Number one, they actually have to receive the property. Two, the property actually has to be stolen. Three, the person who receives the stolen property actually has to have knowledge that it is stolen. And number four, upon receipt of that, they have to have the intent to deprive the real owner of the property permanently. Okay? So, receipt. How are you receiving the property? Well, it can be shown by either actual or constructive possession. Okay? So, either you actually possess the property or you get constructive possession, you're holding it for somebody else. Okay? Now, this includes purchases and it includes gifts. So you could buy something that you know is stolen, right? Or you could actually receive as a gift something that you know is stolen. Maybe you have a brother who you know steals TVs, and for your birthday, he gives you a TV, right? Probably stolen. More than likely stolen. Most likely stolen because your brother doesn't have a job. He doesn't have any money. He can't afford to buy you a TV, okay? But he gave you a TV, right? Okay, and the property, of course, has to be stolen. Now, your mental state in receiving stolen property, you must know or you must have some kind of subjective belief that this property is stolen. Like the situation with your brother, right? Yeah, he doesn't have a job. You know he steals TVs, and now he's giving you a TV. Exactly the same kind that he always steals, right? Now, if you truly believe that the property is yours, somebody gives you a gift. You have a new boyfriend, you haven't known him that long, but he gives you a ring and you're like, oh wow, this is a beautiful piece of jewelry. You have no idea that he stole it, but you don't know that. And you actually believe that he had ownership to the property and he was able to gift it to you. That's not receiving stolen property. You didn't know, okay? You don't have the requisite mental state. Now, you also have to intend. Now, let's say you know you've received this stolen property, the TV. You have to intend to deprive the owner of the property, even if the intent is to destroy it or to give it away, okay? You know that once you take this TV as a birthday gift from your brother that you know it is stolen, if you keep it, your intention is to deprive the real owner of that TV forever, okay? Even if you're like, yeah, my brother gave me the stolen TV and I already have a TV, so I don't really need it, so I'm going to give it to my cousin Larry, okay? You gifted it away. You're still not giving it back to its rightful owner, are you? Okay, so that is the mental state, right? Now, it also is considered a federal crime to receive stolen property if it has traveled across state lines or through interstate commerce. So be mindful of the stolen property that you may or may not be receiving. All right, so moving on to robbery. Now, robbery is a little bit more intense, okay? It's the trespassory taking, and you know what trespassory taking is now from our study of larceny, and the carrying away, which is the asportation, you also know what that is, of personal property, right, from another's person or presence. This is where it gets intense. You're taking it from another's person or their presence. And 5, you're using either force or threat. And of course, you have to have an intent to steal the property. Robbery is really, it's it's also a crime against the person because it's a type of assault mixed with a type of larceny. Okay, so obviously now the trespass retaking, it has the same requirements as larceny. But person or presence, what does this mean? It's very important in robbery. Person refers generally to the hands, body, or clothing. So if I'm holding something in my hand and an assailant comes up, a robber comes up, and they threaten me and they're taking something out of my hand, okay? That's my person. If I have something in my pocket, okay, that's taking it from my clothing. All right, presence refers to any time the victim is in control of the property. So let's say it's not on my person, it is not in my pocket or anything like that, but I have it in my car with me, okay? I am in control of that. It is in my presence, and you're using force or threat to take it from me. That's also a robbery, okay? Now, what is this use of force or threat? Well, this is the one that most distinguishes robbery from larceny. If any force is used beyond that which is necessary to simply pick up the property and take it, then it's a robbery. Okay? If any kind of altercation ensues, we've definitely escalated a larceny to a robbery. If I'm fighting back in any way, or I'm saying no, or we've definitely, now, a threat is okay. It doesn't have to be a physical fight, right? A threat of force will also suffice as long as it's immediate. Holding a gun at me and I just hand the stuff over. We're not fighting over it because you've got a gun to my head, okay? So that's a threat of force and it's immediate. It's not one of these things where the person's like, I'm going to beat you up in 2 weeks. That's different. That is not robbery. Robbery has to be immediate. So the mental state of the person committing the robbery, they have to have a specific intent to take the property and to deprive the owner of it, okay? Now, if they have a good faith belief that they own the property that they're taking, that might be a defense. Okay, something else of interest in our theft crime family is something called extortion. It's also known as blackmail, and this is that threat of future harm. Remember I said it can't be 2 weeks from now because that's something else. Hey, it's this something else. Okay, so at common law, extortion only involved public officers. Okay, today, here are the elements. Number 1, the taking or acquisition of property. 2, of another. 3, using a threat. 4, with the intent to steal the property. Okay, so that those are those elements that you have to have. Now, a few jurisdictions require that the extortionist actually receive the property before they can call it extortion. Others require only the threat. The police can intervene. So you might have seen movies or something where they're like, yeah, the money actually has to be delivered to the person for us to get them. Because in those jurisdictions, you actually have to have that transfer of property. And the extortionist actually has to receive the property. Okay, so what are these threats we're talking about, right? This is any kind of future physical harm, like I'm going to beat you up in 2 weeks. Or it could be harm to your reputation. I'm going to send nude photos to the world, and, if you don't give me this money, that's threatening somebody's reputation. Or you say, oh, I'm going to tell everybody that you went bankrupt. Just things that you don't want people to know that could harm your reputation. It could be a combination of both physical harm and or harm to the reputation. It could be physical harm to somebody in your family. It could be a threat of reputation to somebody in your family that you care about. It could be something where it's threatening your business and just say, hey, look, I'm going to tell everybody that your business sells tainted food and people are going to get sick if they eat there. I'm going to lie about it, but it's going to be enough that it's going to ruin your business and your financial status. Okay. I'm going to tell your wife that you had an affair. These are all things that it might be perfectly legal to tell someone's wife that the husband is having an affair. There's nothing illegal about that. It's mean. But it's the type of thing that somebody wouldn't want to happen. So they might be willing to pay to stop that from happening. Okay. Now, The federal government has made it a crime for federal officers to extort the public. The federal officer cannot threaten physical harm, cannot threaten the reputation of a business or the financial status or the family relationship of a member of the public in exchange for something of value. So they may say, look, if you endorse my candidacy for the Senate, then I won't tell the world that you are stealing money from your shareholders. Okay? So that would be something that would be extortion. Okay? So that would be a public officer doing something wrong. Now, to be involved in an extortion that involves or interferes with interstate commerce, that is also a federal crime. And extorting someone by threatening to expose some kind of violation of federal law. And that's one of the things that I just mentioned is that, oh, and I'm not going to tell people that you're stealing from your shareholders. That may be a federal crime, and you can't threaten, you can't use that to extort something of value for yourself as a public official in exchange for something else that the member of the public is what you would require them to do. Okay. Now, I mentioned way at the beginning of this lecture that some states have just done away with this. Okay, so now remember the umbrella of theft crimes. We've got larceny, false pretenses, and embezzlement. These other crimes that we talked about fall in there somewhere. They fall under those. But the three big members of that family are your larceny, your embezzlement, and your false pretenses. Now, some states have just said, this is too complicated. This law is 600 years old, and other things have been added over time. We just kind of want to make it as easy as possible. So we're going to consolidate false pretenses, larceny, and embezzlement into a single crime called theft. That's a consolidated theft statute. Now, each jurisdiction includes different crimes under this big umbrella, but they all include your larceny, embezzlement, and false pretenses. Now, robbery generally isn't included because of its significant threat of harm. It's usually outside of the consolidated theft statutes. Now, what makes this important, and the reason why states did this, it's because these statutes are written in such a way as to cover all three of the big common law crimes. So, in an instance where a jury decides that a defendant has committed a larceny, but not an embezzlement, they can still convict. Because what would happen under the common law is that if you just had one element off, when the person really committed a larceny, but you charged them with embezzlement, well, if it didn't meet the criteria of embezzlement, you couldn't just charge them with larceny. That person would be free to go. So these states are like, look, this person is bad. They've done something. And if the jury thinks that it's larceny and not embezzlement, we can still convict them of it. Okay? And that was the whole idea of putting together the consolidated theft statutes. Now, the Model Penal Code has also addressed consolidation. Okay, so they have recognized these forms of theft, okay, some of them, okay? Theft by taking, which covers your larceny and your embezzlement. Theft by deception, which covers your false pretenses. They've also included extortion. They've included theft of property known to be mislaid, misdelivered, or lost with no reasonable attempt to find the rightful owner. Like, you know something doesn't belong to you, and you know the person wouldn't have just like left this on the sidewalk, but you didn't bother to try to find who the rightful owner is. They've included that in the Model Penal Code Consolidated Theft Statute. Theft of professional services by deception or threat. Okay, this is when you're trying to get a doctor to help you and you're threatening them, hey, if you don't fix me, I'm not going to pay you, but if you don't fix me, I'm going to break your legs. Okay? A conversion of entrusted funds. This means, remember, conversion, which was a part of embezzlement. Somebody gives you money and it's entrusted to you and you convert it to your own use. Or the unauthorized use of another's automobile. They have included this in this consolidated theft statute in the Model Penal Code. So remember, the Model Penal Code is not law. It's just suggested by scholars unless a state has adopted and enacted the Model Penal Code statute. Now, like I said, a lot of states already have consolidated theft statutes, and some of them mirror the Model Penal Code. Now, remaining separate from the Model Penal Code, just like in most states, robbery, and also forgery. They've excluded that from the consolidated theft statutes for the Model Penal Code. All right, so something else that's out there that is relatively recently, when you're talking about laws that are 600 years old, so this is pretty recent, is something called identity theft. It's within the last few decades, right? That's whenever somebody takes another person's identity, their name, their social security number, their address, any kind of identifying information to make themselves appear to be a different person that actually exists. Okay? And they want to represent themselves as that person whose identity they have stolen, because maybe that person has really good credit and they think that they can get a credit card in that person's name. It's one of the main reasons why people commit identity theft. Okay? Now, your mental state in most statutes is an intention to either gain something of value through deceit or to commit any other crime. You're pretending to be this other person so you can get something of value. Now, a defendant can be convicted both of identity theft and of any other underlying crime that may be there because you have pretended to be someone else. Okay? Now, this is both a state and federal crime. It's pretty serious. And it's very difficult for victims who are, because it takes a long time usually to repair their credit and to repair their reputation. So it is taken very seriously by all of the jurisdictions that have identity theft statutes. Now, something else that actually falls under this idea of crimes against property and habitation would be the actual destruction of property. We talked about arson way at the beginning of this lecture, right? That's whenever you're setting something on fire or you're blowing it up, right? Well, destruction of property is where you're just destroying property and you don't have to use fire, okay? It's, breaking something that doesn't belong to you, spray painting something, you're defacing it. This is commonly called criminal mischief. It's usually a misdemeanor. It's a criminal offense of intentionally destroying another person's property. In your mental state, you specifically have to intend to destroy that property. This isn't an accidental, oh my gosh, I accidentally broke that flower pot of yours because I backed my car into it. I'm so sorry. That was an accident. That was not intentional. You have to intend to break something. Okay? And this includes all types of destruction that affect the value or the dignity of the property. When I say dignity, a lot of times these crimes involve, somebody spray painting a slur on something. When I was in high school, this girl who didn't like another girl in the school, she went to that girl's house and she spray painted the word thief on the girl's garage. And it was just huge. She misspelled the word thief too, so, But it was just a terrible thing. But she destroyed that garage door by defacing it. Even though you could, scrub that off, she destroyed the dignity of the whole house by spraying something on the house. And so that could be destruction of property. It's criminal mischief. Some places call it vandalism. Also, there have been cases where people have, destroyed headstones in cemeteries. That not only destroys the property, but it destroys it affects the dignity of that type of special property. Okay, now, computer crimes. Computer crimes, this is a fast-growing and ever-changing area of the law. Every time I turn around, technology is advancing. The law has been slow to catch up. The current framework of the law, as it is very jurisdictional based. It's very based to geography. And as you know, the internet goes everywhere. It is worldwide, okay? So there are some laws that apply in some jurisdictions and some laws that apply in others. And it's very difficult to sort of encapsulate all of the internet in one universal law to help everybody understand what they are supposed to do and not do. So I just wanted to mention that before I get into the two basic types of computer crimes. Nobody ever thinks about this one, but the first one is where the computer is the target of the crime, the actual computer itself. Someone's laptop, for example. That's when somebody steals your laptop, okay? That's a computer crime. They stole your computer. It's theft, right? But they might also steal just hardware from your computer. They might steal software. Obviously, they might destroy it. They might put a virus onto your computer to destroy your computer in some way using that virus. Okay, that is one example of the first basic type of a computer crime. The second one is where you're using the computer to actually commit a crime. And that's what I was talking about with the internet, because that's the one I think that is causing the law so many issues. It's causing a lot of problems because it's very difficult to regulate such a fast-growing, ever-changing technological adaptation for our world. It really is something that hopefully most, the laws that are on the books now will be outdated soon. So they're constantly having to revise them. So now, when you're using your computer to commit a crime, some of the things you could do, you'd be like cyber stalking, distributing illegal material like sending or possessing child pornography. Those types of things obviously are crimes, and that all falls under this idea of a computer crime. Okay, well, I hope that this lecture was helpful to you. Again, it was the basics of these basic crimes against property and habitation. Hopefully, I was able to give you a little bit of a historical context and talk generally about how these crimes are viewed today. And if you like it, please like and subscribe, and I'll see you next time.